Hello, everybody. This is Samantha from the law offices of Samantha Wolfe, and I'm here today to bring you this month's virtual seminar. I'm excited to talk about it. I always like to talk about business planning. So today, the title of today's session is called Boss Moves: Estate Planning for the CEO in Your Family. And we're going to break it up into two parts. So today is part one. We're going to talk about business formation and how to set up your entities with the Department of State and all the requirements that you need there. So I'm excited to dive in. Now, just as a reminder, you can always check out our YouTube videos. You can access them by going to our website. We have a direct link to our YouTube videos on our website, so you can check it out there. And you're always welcome to call and we can schedule an appointment as well. Our number is 717-655-2676. With that being said, I'm going to go ahead and share my screen because I do a PowerPoint with the information that you're welcome to follow along with. So hang on a second. Let me share my screen here. Okay. Perfect. All right. All right, there we go. So again, it's Boss Moves: Estate Planning for the CEO in Your Family, and it's a part one. And I love talking about this stuff. I don't feel like we don't get to talk about it enough at our office. So let's go ahead and start chatting about this. So in today's virtual seminar, we're going to talk about the importance of proper entity formation. We're going to go over different business entities, how to properly form a business, key legal documents and agreements that you would need for a business, commonly asked questions, and we're going to give you some next steps and resources. So setting the stage, why proper entity formation matters. I've been practicing for a while now, and one of the things that I see when I'm meeting with clients is they will come in and they will have real estate maybe, and they'll tell me, well, it's in our entity. They may say, yes, we have an entity, we operate, have a bank account, all of that. But then when I go onto the Department of State website, sometimes their entity isn't created the way they think, or it might not even be registered with the Department of State. So the reason why this is important is that when you properly set up a business entity, it does protect your personal assets from business liability. But you have to make sure that you're properly forming the entity and you're following all the requirements for the entity in order for that to be true. So you're going to want to properly set up the entity, number one, for risk management purposes. Number two, you're going to want to properly set it up for tax efficiency. So you want to choose an entity structure that might lower your tax burden or at least keep your tax burden neutral. So setting up the proper entity would allow you to do that. Number three, credibility. So a properly formed entity can enhance your professional image. It also just kind of lets people know that, yes, this is the entity. It allows you to operate, get your name out there so people know who you are, associate you with the entity. And then lastly, having a properly set up business entity does wonders for your estate and succession planning. And the reason why is because an entity centralizes the management and allows you to then be able to move assets without having to move every particular asset. Instead, you're just moving the entity as a whole. So it's great for succession planning. Common business entities, we have a sole proprietorship. They're the easiest to start. Not a lot of fuss here, not a lot of expense for a sole proprietorship. But the problem is you get no liability protection with a sole proprietor. So if you look at it this way, it's easy, it's simple, but you're really not getting any benefit for the sole proprietorship. Another option would be a partnership, and you can do it as a general partnership or as a limited partnership. Now, the benefit of a partnership is normally it's multiple owners sharing profits and liabilities, where with a sole proprietorship, normally it's just one person, or it might be husband and wife that are kind of treated under the tax size as one entity. Partnership allows multiple people to come together, contribute, share in the profits and losses. Now, the general partnership doesn't give you asset protection or liability protection. You're only going to get that protection if you use a limited partnership. So when you're looking at partners, or partnerships, just know that there are two ways you can set it up. The default in Pennsylvania is if you have more than one person together in an entity. So for example, if my sister and I start a bakery, the default is that we are a general partnership unless we elect something different. So Pennsylvania's default, when you have multiple owners, would be a general partnership. Most clients go with a third option, which is a limited liability company. The reason is it's very flexible, it gives liability protection, and it's considered a pass-through entity like a partnership. So typically you don't have to worry about paying the two levels of tax that you do with a corporation. So you get the ease of setting it up, plus you get the tax benefit. And then lastly, you might have a corporation. Now, corporations give you the most liability protection. The formalities can be a little bit more complex, and definitely the taxing is a little bit more complex. Now, if you're set up as a corporation, you can elect S corporate status for tax purposes, which means that you can have the flow through taxation that you have for an LLC or a partnership. Now, in order to be an S corp, there are a little bit stricter requirements as to who can be owners in the S corp. For example, you have to be an individual, or if you're going to have a trust be the owner of shares, it has to be a grantor trust. Typically, you have to have less than 100 shareholders for an S corporation. So there are some stricter requirements than like a C corp or for an LLC or a general partnership. But if you want the strong liability protection and you still want the preferred tax treatment of an LLC or a partnership, an S corporation might be the way to go there. What's interesting is when you set up the entity, you're setting it up through the Department of State as a corporation, and you're just electing S corp status or treatment. When you file your taxes, your accountant can actually file a form that would allow you to be treated as an S corporation. So don't think if you go on the Department of State website, you're not going to find forms for an S corporation. You're going to file as a corporation and just elect to be taxed as an S corp. Same goes with an LLC. You can elect S corporation or S corp too for taxes. This is helpful because it means that you might not have as much self-employment tax to pay. So I see a lot of entities set up as a corporation and then elect S status, or as an LLC and elect S status. So just know that the entity that you're choosing, you're looking at liability protection and you're looking at taxation. So usually you want to talk to both your accountant and your attorney to make sure that you're picking the correct entity in order to make sure you're getting both the liability protection and the tax benefits that you're looking for. So when you're choosing the right entity, you want to look at ownership structure, how many owners, members, shareholders are involved. You know, is it just one? Is it more than two? How many people are you talking about? What liability concerns do you have? So do you need maximum protection? What is the business that you're going to be engaging in, and how risky is it? You want to look at the tax implications. Do you want it to pass through so that you don't have corporate tax, which would be tax at the corporate level and at the shareholder level, which is what most people want. And then lastly, the management flexibility. So who's going to handle the day-to-day control, and how do you want that to be structured? So all of these questions go into choosing the right entity. Now, when you're forming your business, there are a couple of key things that you need to do. So you want to make sure you're selecting the entity you want. Do you want an LLC, corporation, partnership, etc.? You want to make sure that you're going to the Pennsylvania Department of State website. There is a Bureau of Corporations and Charitable Organizations. That's the entity or the governing body for business entities in Pennsylvania. So you're going to want to file or register your entity with the Pennsylvania Department of State website. You'll actually get on the website. Now, the important thing to know is that you're also going to need an EIN. That's through the IRS website. And here's the interesting thing, and I've learned this over the years of practice to try to make it easier. So when you decide you want an entity or want to create an entity, you're going to go to the Department of State website first, and you're going to look to see if the name is available. Once you know the name that you're selecting is available, then you're going to actually jump over to the IRS website and get an EIN, because when you're filing these registration documents with the Department of State, you will need the EIN in order to fill out the paperwork. But don't get the EIN first, because if you get the EIN first and that entity is not available, it can be problematic. So just go and search the name first and see if it's available. Key documents, if you're doing an LLC, it's a certificate of organization. If you're doing a corporation, it's articles of incorporation. So the Department of State website has a great interface, and once you get on there, it can help guide you as to what forms you need. Our office does help companies or individuals create an entity and file the paperwork. We have an online portal because it's much easier to do it online than to fill out the paper copies of the forms and submit them to the Department of State. Now, when you're naming your entity, the first thing to know is that Pennsylvania doesn't allow you to use a P.O. box anymore. You actually have to have a physical address on the certificate of organization or on the articles of incorporation. So just make sure of that. And the name must be distinguishable from existing PA registered businesses and comply with the naming restrictions. So you can't have any misleading words in the title. And typically you're going to put what the purpose of the entity is, so that way they know. Okay, so the naming availability, you're going to check the name availability through the Department of State's online database. That's where I was saying, go to their website. They have a business name search. You can look through, see if the name is available. For a fictitious name, if you're operating under a name different from your legal name or entity name, you're going to want to file a fictitious name with the PA Bureau of Corporations. So for example, if I would ever change my law firm name and want it to be, I don't know, I'm going to use my sister's name. She's not an attorney, but let's just say she went to law school and became an attorney, and we wanted to change the name of the entity to Wolfe and Blair. What I would do is I'd probably keep the law offices of Samantha Wolfe as the official name, and then I would just file a fictitious name for Wolfe and Blair. So that way it's still connected to the underlying original business. Now, there are some restricted words. Words like bank, trust, or insurance require special approval. So if you're looking at those type of names, just know you're going to have to get special approval in order to be able to use those. Now, filing with the Pennsylvania Department of State, you're going to complete the certificate of organization. If it's an LLC, if it's a corporation, you're going to file articles of incorporation. There are different forms as to whether it's a for-profit or a nonprofit, so just check that out. The submission is online via the Pennsylvania Bureau of Corporations and Charitable Organizations. They use Pennsylvania Business One Stop Hub. So again, we have an online portal, but anybody can do that. You can create an online portal. Or by mail, you can send it directly to the Bureau of Corporations and Charitable Organizations. There is a filing fee. Currently, the fee is $125, but that can vary and it changes from time to time. So just know that there will be a filing fee. You can do it via credit card and submit a check. Processing time typically takes a few business days online, longer if you do it by mail. Now, this is important because sometimes we have people who are creating an entity to purchase real estate. And so if they wait too long, you're usually running up against the closing to buy the real estate. So you want to make sure you're doing it in plenty of time. Then we have the Pennsylvania governing document. So if it's an LLC, it's an operating agreement. If it's a corporation, it's bylaws. If it's a partnership, it's a partnership agreement. So it depends what type of entity you're using as to what the governing document is. It's kind of confusing. Just know that it doesn't matter what it's called. It's just the rules of the entity and how it's going to be run. So whether it's an operating agreement, bylaws, or the partnership agreement, it's just basically saying how do you vote, how do you make decisions, all of that good stuff. An operating agreement is not strictly required by PA law, but it's strongly recommended. And sometimes, a lot of times, the bank will require a copy of the governing document in order to open a bank account. So usually they'll ask for the EIN and the governing document in order to open the account. Typically, it's going to help outline how you handle disputes between the owners, whether it be members of an LLC or shareholders of a corporation. And it's also going to help protect the LLC or the corporation. And the reason it does this is because there has to be a set of rules that make it different from you personally. So one of the things is, if you ever would get sued, the first thing that they're going to ask for is a copy of your corporate book to see if you have governing documents in there to outline what the rules are for the entity. Now, PA tax and registration requirements, you're going to obtain an EIN. Like I said, check to make sure the business name is available before you get your EIN. Once you know the entity name is available, go get your EIN and then come back and file the stuff with the Department of State. So an EIN is a federal employer identification number that the IRS issues, and it's required to open bank accounts, hire employees, do payroll taxes, all of that. You want to register with the Pennsylvania Department of Revenue. So this would be if you have sales tax, it might be employer withholding, unemployment compensation. You want to make sure you're filing the proper forms with the Department of Revenue. You may need to file local tax registrations as well. And then annual and periodic reports. LLCs, Pennsylvania does not have an annual reporting requirement for domestic LLCs, but you have to keep your information current. Corporations must file a report if no other filings have been made for a 10-year period. Now, recently, Pennsylvania did institute a law where if you're registered with the Department of State, you have to file an annual report. So know that no matter if you're an LLC or corporation, you're going to file that annual report. Now, at my office, because I'm a professional services corporation, I have to file another annual report and pay a fee for that. But that's because I am a professional services. So doctors, dentists, lawyers have to do that. But everybody else, the annual report you're going to get on the Department of State website, type in your business entity name. And once it comes up, you'll select your actual entity that's listed, and you'll get an entry, and you're going to click on, first you have to claim it, and then what you can do is file the annual report, and you need to make sure you're doing that. And if you're not sure if you need to file one, you can reach out or ask your accountant, but you need to be filing those annual reports with the Department of State website. When it's talking about annual reporting requirements, one of the things that we're talking about here is like annual meeting minutes, and whether you have a registration form, you have to file annually. What I'm talking about is something new that started, I believe it actually started this year, where you have to file an annual report for the entity with the Pennsylvania Department of State website. So you want to make sure you're complying with that. So ongoing compliance in Pennsylvania for corporate formalities. For corporation, you have to hold annual meetings, keep those meeting minutes, maintain accurate records. And LLC should still do this. So even if you're not a corporation and there's nothing required under PA law about annual meeting, I still encourage my clients to do that. The reason is remember, we're trying to show that this is different from you personally to get the entity protection. So when you have minutes and you're having annual meetings, then that's a way to show that this is different than you personally. You probably have meetings that you're not even accounting for, because if you meet with your accountant to go over your financial records or to review tax returns, that's considered an annual meeting. You just then need to memorialize that. State updates. PA requires certain filings every 10 years. You want to ensure timely updates with the Pennsylvania Department of State if you're a registered agent. And like I said, there's now a new annual filing requirement for entities that are registered with the Department of State website. You also want to check to see if there's any local licensing that you need to do. All right, let's talk about key formation documents. These are those governing documents. So it might be an article of incorporation, might be articles of organization if you're an LLC. It officially creates the entity. You might want to do bylaws or an operating agreement. So the articles of organization or incorporation with the Department of State website. Then you have the governing document, which is the bylaws or operating agreement that normally you work with an attorney to create. That's what governs, has ownership, decision making. How does all of that happen? Then there are shareholder agreements, buy-sell agreements, and then the EIN, which we talked about is necessary for taxes, banking, hiring, all that good stuff. So when we're talking about the governing document, one of the things you want to make sure you're outlining is ownership percentages, who owns what portion of the company and what percentages? What's the management structure? Is it a manager managed versus a member managed? So a member managed would mean that if we have 5 members of the LLC, it's all done by vote. Might say, you need a majority in order to make decisions. But you could also have a manager managed, and that would be where you might have 5 members, but you elected to have one person make the day-to-day decisions. So you can do either way. Decision-making procedures might have voting rules, meeting requirements, what type of notice requirements for those meetings. And then sometimes in the governing document, you might have buy-sell provisions, like what happens if someone leaves, retires, dies, or would want to sell. That's what would be in the buy-sell provisions of your governing document, your operating agreement, bylaws, that good stuff. You can also do a separate buy-sell agreement too that just says if somebody dies or wants to sell, this is how they go about doing it. Now, capitalization and funding, one of the things you're going to want to think about is what's the initial way you're going to fund the business? Are you doing cash contributions, property contributions, or services contributions? You want to make sure you're maintaining capital accounts, track anybody's contributions into the entity or any distributions. You want to look at the debt versus the equity, decide whether to issue shares, membership interest, or take on any loans. Business bank accounts, you want to make sure that's separate from your personal account to preserve that liability protection. Now, here are some factors that you look at in order to consider if you have the liability protection. So the first thing is you want to make sure that there's no way that they can pierce the corporate veil. Risks if personal and business finances are not kept separate. So do not commingle. When you do that, then it looks like you're not really an entity, and then any creditor can pierce that corporate veil. That just means that they can get assets in the business and personal assets because you didn't keep them separate and distinguished assets. You want to make sure you have adequate insurance, so maybe a general liability, a professional liability, any other coverage that you would need there. And I would encourage you to talk to your insurance person to talk about the different types of insurance and making sure you have that adequate insurance. You want to talk about compliance, so following those corporate formalities, the annual meetings, the record keeping, and the annual filing that's required by the Department of State website. And then you want to understand if you've made any personal guarantees. So when might you be personally liable? Estate planning considerations. This is really important as we're planning, as we age and planning for that second half of life. You want to ask yourself, how will your shares or membership interests pass to your heirs? You can use documents in order to make that a smoother transition. And it could be a trust, it could be a will. And that's just coordinating the business interests with your personal estate plan to ensure that it's going where you want it to go. It can be a will-based plan where your will is saying this business entity goes to these individuals, or it could be done through a trust where maybe it's staying in trust and there's going to be a trustee. Either way you do it, that's really important. You also want to remember it starts with the powers of attorneys. So you may have a financial power of attorney. You can have it one for personal assets and one for the business, and it can be different individuals. So if you have a key employee that's really helpful in maintaining the business and running the business, you may name them as the power of attorney for financial purposes related to your business entity, but then you may have a spouse or a child as the agent under the power of attorney for your personal finances. You want to make sure that you have healthcare directives as well. And then the last estate planning consideration that's really important is the buy-sell agreement. That's just, it could be in the operating agreement or in the bylaws, just embedded in there that says, if I die, this is what happens. But you can also do a separate entity, and that's just separate document for the entity. And that would say, if someone dies, someone retires, someone leaves the entity, as far as an owner, what happens. And this just ensures that if you would become incapacitated, if you would die, that your entity is going the way you want it to go. I'm always surprised at how many people haven't had that conversation. And so the question just becomes, when each partner or member or shareholder dies, what happens to their business entity? Keeping your entity current, you want to make sure you're looking up the annual reports and state filings. So one of the first things I do when I have a client that has a business entity is I look them up on the Department of State and just make sure all their information is accurate. Is the registered office where they have is where the business operates out of, is that correct? All of the officers correct? So you'd be surprised how often people forget to update the entity. And it could be that it's been passed through multiple families and multiple generations, and it still shows the original people. And so you want to make sure that you're updating that. You want to make sure that your ongoing record keeping is accurate. So updating ledgers, balance sheets, tax returns. You want to make sure that you restructure your business as it may grow. And then you want to make sure you're looking at least annually, reviewing those entity documents and making sure it aligns with your estate plan. And again, that's where you want to get your insurance person, your accountant, and your attorney all together to make sure all of this makes sense. Okay, let's do some commonly asked questions. So why do I need an LLC versus a corporation? So we've talked about this a little bit. An LLC does offer more flexibility in the management of the entity, and usually there are fewer formalities if you do an LLC. They're just quick, they're easy, they're efficient to set up. Corporations might be better if you seek outside investors or if you plan to go public. Both entities provide the liability protection, but the tax treatment is different for those entities. So it's going to depend on how do you want to be taxed, how many owners are there, what do you know the owners, those type of things. So the choice depends on long-term goals, ownership structure, and capital raising plans. What happens if you don't have an operating agreement in place? Number one, you might have problems or trouble opening a bank account, because more and more I'm seeing banks require that governing document, whether it be an operating agreement or bylaws, so that they can open the bank account. They'll ask for the EIN and a copy of that. But beyond that, a governing document usually addresses if disputes or issues arise, how do they get handled? What do you want to have happen? If you don't mention it, or you don't have bylaws or operating agreements to state that, then you're stuck with whatever the state law default is. And the problem with that is you may not know what the default is. And number two, you may not want it even if you know it. So just make sure you're thinking through that. The governing document can outline if disputes arise with partners due to unclear roles or rights. Usually you're going to outline that. And courts may disregard your LLC or entity structure if formalities are not observed. And one of the ways that you can make sure they are is to have the governing documents in place. And then you want to make sure that you put an operating agreement in place to help guard against all of these issues. How often should I update my entity and estate planning documents? You want to review them yourself annually, or if there'd be a significant change, so new owners, major asset purchase, or maybe changes in personal life, somebody getting married, somebody getting divorced, somebody having kids, you want to make sure you're considering all of that. So if you have a significant life event, review your documents. Otherwise, you want to make sure you're reviewing them annually, and a great time to do that is when you're dealing with the tax returns. You want to make changes to either set of documents when your circumstances change or your business vision changes. And it's always a good idea to have an attorney review both sets of documents at least every couple of years to ensure that your estate plan and your entity documents are up to date with current regulations, and comprehensively they do what you want and they account for the other. You want to make sure your business entity documents address or reference your estate plan. You want to make sure your estate plan references the entities that you might have. Proactive updates prevent costly mistakes and ensure the alignment with your goals. How do I integrate business interests into my estate plan? This is where we talked about it briefly. You can use trusts, wills, buy-sell agreements to talk about who inherits your share of the business entity. One of my favorite things is to use a trust, because if you have two partners and they want it to go down through their families, you can have different provisions or identical provisions in each trust that are basically saying something happens to one of us and the next generation decides to sell, they have to first offer it to the other trust, and here are the buyout terms. So I do that a lot with farmers that might own real estate and it's part of a partnership. And so just being able to say, if they sell the real estate, they first have to offer it to the other owner, or it might be that we want to allow the entity to be able to rent the land for as long as they want to operate the farm. And we can put those provisions in the trust so that way it ensures that the property can be rented. You want to make sure you're coordinating business succession with personal estate planning because that avoids any conflicts. And it is recommended that you work with both an estate planning attorney and a business attorney, or it could be one and the same. We do both estate planning and business planning. So you want to make sure that you're aligning those strategies. And I think it's important to talk to your accountant and your insurance person, have a good team behind you to make sure that all of your bases are covered. What if my business changes significantly? So if that would happen, then you want to obviously talk to an attorney to ensure compliance with state and federal laws. You might want to restructure. So you might want to take it from an LLC to a corporation or vice versa. And you may want to amend your operating agreement or bylaws to reflect any changes or new operations. What happens if I become incapacitated or pass away unexpectedly? This is where that power of attorney can become really powerful. So if you're incapacitated, who's going to vote? Who's going to make business decisions? Are you going to have a separate business power of attorney and a personal power of attorney? So you want to make sure you're thinking through that because somebody can step up and step in if needed. Without proper planning, business operations may stall, ownership transitions can be contested. One of the hardest things I had was I had a sole proprietor that passed away. And so the business was under his EIN, and he had a good many employees, and there was payroll. And the issue was that all the bank accounts were frozen because it was tied to his social security number. So in that case, maybe having an EIN and actually formally setting up the entity would have been really helpful, because then we could have rolled on with the payroll taxes and all of that. So you want to make sure you're thinking through that. Now, we were able to get the new owner, who was the son, access to those bank accounts relatively quickly, but it still was a little bit of a lag time, and you don't want to lose employees because they're not getting paid. So you want to think through that. And a buy-sell agreement can govern how your share is valued and how it's transferred to your heirs or other co-owners. So another example is that I have two brothers who are in business together, and one brother is single, the other brother is married. And so talking to them about when one of them dies, what happens to the wife of the one brother. So she doesn't want to have to interact with her brother-in-law if something would happen to her husband. So setting it up so that she receives a certain amount when he buys her out, making sure she's comfortable with that, and going ahead and outlining the terms so that she doesn't actually have to negotiate with her brother-in-law was really important. So you want to make sure that you've thought through that and that your buy-sell agreement addresses that. The other thing that I ran into not so long ago was that I had multiple business owners, but the buyout was being funded by life insurance. And in that instance, one of the owners was not able to get the underwriting for a policy. And so we had to address that in the buy-sell agreement because all the other owners could get a life insurance policy except for this one. So talking about how were we going to address that, that was all addressed in the buy-sell agreement to make it easy and fair between all the members. Okay. So just know there's going to be a part 2 about this, but I wanted to open us up about how to create the entity with the Department of State, how we go about doing that. The next step would be to call our office or to email Amy at our office to schedule an initial consultation, or even if you have an entity and you just need us to review those governing documents or review the Department of State entity formation filings with you, you can always reach out to our office. We're located at 20 East 6th Street in Suite 206 in Waynesboro. And I hope I was able to convey how much excitement I have about these business entities and making sure they're set up properly. So I would always love to talk to clients about that. So whether you have an entity, you're thinking of creating an entity, I'd be happy to look at that governing documents, what you have, and let you know if there are any changes that need to be made. Okay, that covers part one. Stay tuned for part two. We will have a lot of more information about business planning. But thank you so much for joining us. My name is Samantha, and I'm with the law offices of Samantha Wolfe. You can always check out our YouTube channel and our website. We're always welcome or looking forward to feedback about any ideas or any information that would be helpful to clients. So feel free to reach out to our office. Thank you so much. I really appreciate you being on today's seminar. I hope everybody has a great day. Thank you. Bye-bye.